welcome. We are starting the recording. I'm inviting the folks that are here live to go ahead and share whenever they're ready. When you share or ask a question, make a comment, you are not interrupting, you're helping. Oftentimes, the more student involvement, well, actually every time you get more student involvement, you get a better result, a better recording, because it's more engaging for yourselves and for the other students that want to listen by recording. It makes the recordings of value when you have student involvement. Things have a greater meaning when it's in response to a peer's question or comment. So keep doing that. I introduced myself last time. It does make a huge difference which people are hired to assist. In this class, it's not just saving $10,000, but in some cases, saving a whole career. When you bring up an actual statute, case, or rule in the court rules, that something has to be done different according to a statute, case, or rule in your state. So if something has to be done differently than the law firm is planning, and you bring up the authority for that, you may save one career. You may save the law firm not just money, but like I say, suspension, which definitely hurts a career if an attorney is suspended. They really don't have an excuse either if there's something in the law that sort of, let's say, that requires them to keep confidential, and then they fail to. They think there's an exception that doesn't exist, or they think that there is no exception, but there is. You can save a career by bringing that up. Do you have to get into people's faces and act like you are in charge? No, you just bring things up. Most of my students are not pushy type people. They're real reluctant to push their own views forward and so on. That's okay. A lot of detail workers are not liking to be confrontational and so on. You don't have to. You just put it in writing with the correct citations. So citations is not a, quote, academic, unquote, thing for paralegals. It's a pathway to a higher level. We were talking about this before we got started. Yes, I do go cross-country skiing. This is an old picture, but I did go on Sunday, and then I went snowshoeing today. So anyway, when possible, try to balance out your lives too. It's easier to fulfill ethical duties if you're feeling okay yourself. It's easier to gain confidence. It is going to take a lot of confidence to bring up an ethical issue to a law firm when you don't own the law firm. And I know some of my students say, well, I'm going to become an attorney at some point after paralegal. And fine. But even if you become an attorney, it's still going to be awkward, difficult, hard to be assertive if you have to bring it up for another lawyer. And of course, if you're a paralegal and remain a paralegal, it's awful, awkward, difficult, requires more assertiveness than people are comfortable with to bring it up. And that's why I also suggest bring up in writing. You say, hey, here's what I found about confidentiality, and here's how I think it might apply to a new case we have. That would be a good paralegal way to do things. Yeah, Autumn agrees with that. Put it in writing. Is it always possible? No, but quickly getting a citation down there and then let them explain it to themselves. Even judges have a hard time convincing lawyers. The judge will say, you're not following the rules of procedure, counselor, you know, and mentally, you know, we're going, okay, judge. But mentally we're going, where is this judge coming from? But if the judge gives us, he says, well, it's in this rule, and he gives us the citation, we're going to quickly look it up and comply. If he doesn't give us the citation, we're not going to ignore the judge. We're going to go along with it as long as we're in that judge's courtroom, but are we going to learn our lesson? Maybe not, unless we look it up. Do you guys see kind of where I'm coming from with this? Does it make sense? And I'm not trying to say that lawyers are stubborn and all that. I don't suppose they are more stubborn than other people, but lawyers are people that they make a living by trying to be more authoritative than other humans, by being right. You don't make any money by saying, "Oh, I really don't know how to solve your problem. I'm not very capable." You don't make a living that way as a lawyer. I'm going to turn off video now because it just saves us a little bandwidth here. And then just kind of, if you think that your mic is having a little bit of problems, just temporarily mute yourself. And then enter something in the chat, and I will mute myself and give you a chance, okay? Just say, I have a comment. So confidentiality is a good example of something where it's much more thorough than in other normal, what I call friendship ethics. And I probably have mentioned this before last week, but in friendship ethics, we aren't fanatics about confidentiality. We're reasonably confidential, but we might breach it if it's for somebody's own good. Somebody says to you something that is really going to hurt another friend, and so on. You may end up having to talk to somebody like somebody that both sides trust, or so on. You know, certain things you will breach confidentiality in friendship ethics. You'll try to bring friends together. You don't just take one side typically. Okay, I've got to answer something. Just a sec here. I'm going to pause. Okay, we're back on for the recording. So we're working on confidentiality. There are exceptions, but just remember that the exceptions are much narrower than you would use in ordinary life with friends. You're much less likely to be able to breach confidentiality. And then you also want to be able to talk in the discussion about unintentional disclosure and how to remedy it. And you want to help the law firm avoid breaching confidentiality with technology. It's easy to cause a problem. It's hard to fix. This is one of my, it's serious subjects, but in order to tackle serious subjects as serious adults, we sometimes remember it better when we try to be a little bit more lighthearted about it. So this is my quote. So I'm going to try to be a game show for a little bit, okay? And we'll just play it where you can enter it in the chat, enter the answers. Is that okay, folks? If you don't know the answer, don't be embarrassed to try. I realize you're new to Module 2. You haven't had necessarily a chance to really study, but let's just give it a try, and it does help. Have more fun than you are ready to have, okay? Can you hear me now? Okay. Okay. Who else has authority to impose discipline? Other than state Supreme Courts? And it might be two answers. Okay, A and B. Other answers? Yeah, you're mute now. Yes, A and B is correct. Voluntary does not have that authority. They sometimes assist the professional responsibility boards, but if somebody does not agree with their determination, they can, the board will have to decide, or the director of professional responsibility. And if somebody does not agree with the director, they can go right to the state's highest court. Class for its instructor. Answer in 5 seconds to win. Which has authority to regulate licensed attorneys? The ABA, each state's top court, or the Federal Trade Commission? Okay, Autumn is winning for the students. You guys get a point. So 1 for the students. UPL and legal ethics is unauthorized people's laws, unauthorized practice of law, or unable to practice law. Let's see some other answers. Okay. Unauthorized practice of law. So the class is 2. Which is not UPL? Paralegal yells at a client on the phone for failure to attend a court hearing. Paralegal drafts, signs, and mails a letter of advice after speaking on the phone to the attorney about it. Lawyer does a probate proceeding in a state in which the lawyer is licensed without getting special court permission. Which of those is not UPL? Not. Remember to really, really analyze the negatives in any question. Really analyze. Sometimes there's double negatives in quizzes. Really watch the double negatives. And then sometimes in a lawyer's analysis that you're reading, there are triple negatives, and I hate that. But I'm sure I was guilty of it when I was practicing law, but then you catch it. I'm going to give me a point because most people didn't get A right away in 5 seconds. So it's 2-1. Okay. It's not UPL to yell at a client for failure to attend the court hearing. It might be unprofessional conduct in a certain sense, unbusinesslike conduct or whatever, but it is not UPL. You don't want to yell at them, but some people need to be yelled at, or they just will not show up. Okay. Oh, I'm sorry. Is he okay? Terrible. Rick. Okay. I almost lost an 18-month-old in the Detroit airport after we attended a wedding and we were on our way home. He took off like a shot, but I caught him. It was the longest 35 seconds in my life. Which can the lawyer reveal? Price of a house is a matter of public record, but the client said not to tell. the statement of a client about how he plans to kill his boss, both, or neither? Just B. B is the answer. So we're 2-2. This came up in my practice, and I really annoyed somebody in the real estate business because I wouldn't tell. And I said, you'll have to just look it up. I can't tell you. Well, you're just wasting my time. Well, I thought we were pals. I said, well, we are pals, but I said my duty to the client goes ahead of my duty to my pals. And that's the case where friendship ethics would have said, well, I could just say it, you know. But legal ethics says I can't say it. Do you see where I'm coming from? The difference between two sets of ethics? On confidentiality, legal ethics is stricter. And you might think certain other things, you know, you might say, well, legal ethics is worse in some cases, maybe you might think. But if instead of how he plans to kill his boss, what about if it had said on how he killed his boss in the past? Then I would have to keep that confidential. Do you see where I'm coming from? Yeah. Go ahead. You can unmute.
I guess I'm confused about the A. I don't understand that. The price of a house is that the client said not to tell who.
Not to tell anybody.
Like if he's selling the house, or?
Like if he's already sold it. It's a matter of public record. So if right. Somebody in the real estate business or just any snoopy person, a neighbor wants to know how much he sold it for, they can just call the courthouse or go up there. Of course, with COVID, it's a little harder, but you can just go up there and say, well, how did this particular legal description or this address, what was the sale price on this? And the treasurer or the auditor in that county will have to tell you. It's a public record. You can get a photocopy of it.
I guess I was just confused about the phrasing of the statement. I didn't get it, like what? Right. I didn't get the scenario, yeah. But I understand now. Yeah, thank you.
Yeah, well, that's basically what happens is something is a public record. Somebody says, well, how much did Billy Boy inherit? And you can look it up in the probate file of his dad, but I'm not telling you. If you call me and you're not Billy Boy or you don't have authority from him, I'm not telling you. You'll have to look it up. Do you see where I'm coming from?
Yeah.
So it's public information, but I still won't tell you. You know, and that sounds weird. You say, well, Olson, you're just giving us a lot of trouble. But it's trouble the client wants. He's not broadcasting it to the world that he inherited only $2 from his dad or that he inherited $200,000. He does not want anybody to know either way. Even though it's obviously not, it's not a total secret, but I can't tell. Which was the attorney required to reveal to the court? Confidential intention of the client to change his plea to guilty if his business associate is subpoenaed to the trial. A secret the client told to his attorney about a civil trial that he intends to lie to the court. It's not supposed to have two words, too. Lie to the court about a document he destroyed on September 15, 2019. Neither or both. Yeah, this B is correct. So you now have 3 points to 2. Students are ahead. The way I resolved this, though, was not to reveal it. What I did was I told this is not precisely what happened in any of my cases, but when I thought a client was going to lie, I would explain to the client that I would not be able to ask any questions of the client. I would have to go to the court, go to the judge and say, my client will testify in the form of a narrative. And the judge would therefore know, because of judges usually are pretty good with the rules, they understand about the rules, they would understand the implication of me doing it wrong, quote unquote. For me to do it wrong, the only excuse for doing it wrong and letting the client just run letting the client tell his own story without being asked questions would be that scenario where I don't believe the answer is going to be truthful to the best of the client's knowledge. And then the client would back off. And we had just said, well, then I'm not going to put you on the witness stand, because if you're going to lie, I can't ask you a question. You can't ask them a question if you believe they're going to lie. And it's kind of but that's what I would bring up. I just say, well, it's going to be obvious to the judge because I can't ask you a question once. So you might as well give up on lying. Because this is truly confidential, you can't reveal this to the court. His intention of the client, his intention, you can't tell the judge anything about pleading guilty until the client actually says, I'm about to plead guilty. Then I can go to the judge and say, my client is now going to plead guilty. But when it's just an intention, I can't tell the judge. So you really got to read these strictly. Microsoft Word encryption is not helpful at all, somewhat helpful, or totally secure. And I don't expect you all to know this one. I got to see who's, oh yeah, you're ahead by one, okay. So see, just take your best shot at this one. Well, Autumn, you just won one for the students. It is somewhat helpful. The purpose of it is it's somewhat helpful because it will disguise a message to an honest opponent who somehow gets the email. So Microsoft Word encryption works this way. Let's whiteboard. So you prepare an email. You attach a Microsoft Word document that has a encryption and password. And then send. And then it goes to the wrong party one way or another. An honest attorney on the other side will never read it. Does that make sense so far? They can see it's confidential because they need a password. Now, a dishonest person on the other side, whether the client or the attorney, can still use methods to convert the file and read it. It's not like super hard software to break it. but you got to know if you have to do you got to know that it's confidential when it's been encrypted. So it is a protection against an honest person accidentally reading it, okay? So it was still better to attach it as a Word doc with encryption and password than it was to just put it all in the email. It was a little more secure. But it's not like totally secure. It can be hacked. And it's not a real hard hack. You don't have to be a if the attorney encrypts something by mistake and then wants the contents back, never goes to anyone else. The attorney types it, then encrypts it, forgets his password. You could go on the web and find the solution and get it back. Okay. You can crack that file if you really want to. But you obviously would not, I should say, I'm sure you would not crack it if the opponent sent it by mistake to your law firm. You wouldn't crack it and say, well, let's get an unfair advantage. You wouldn't do that because it wouldn't be right. Courts and legislatures protect these people with rules against requiring testimony about legal confidences, secrets, and advice. I'll give you a clue. I would like number A to be true, but it really isn't. I would have liked to have shielded my advice from the client blabbing about it because I made money from advice, and certainly they're doing retailing it to somebody else who's probably going to apply it wrongly, but then they're not going to come into me. They say, well, Mr. Olson says thus and so. Well, no, I don't really say that in everybody's case. That's remotely similar, but you know, I would like it to be confidential, but it isn't, okay? So it's actually which? A, B, or C? And I'm crossing out A for you. I'm sort of giving you a hint. Who is actually protected? I'll give you that. C, just clients. Lawyers are not protected by confidentiality. I suppose we could, if I did a specialized contract, like if I did a specialized internet contract for an internet sales company, I suppose I could try to copyright it and say, this particular contract is still my property, even though it's your property. You paid for it, but on the other hand, all I give you is a license to use it for yourself. I suppose I could do that, but typically never happens. Typically just clients. You would have to, a law firm would have to do a lot of work. I'm not sure it's even ethical to sort of copyright your advice. I think in some ways maybe it would be better for lawyers to be able to do it, but they don't. So it's just clients. So you're way ahead now, 5-2. 2 students ahead. Okay. And you won. Students won. We don't need to do this right now. We're going to run out of, well, we're not going to run out of time. We're going to run out of focus power, I'm afraid. But I'm not going to have you do all of this, but I will tout Lexis. It's a research system. It's not a single database. It's a cross-reference system. Cross-reference means that when you find one law, you'll find the other related laws that you need in order to really use and interpret the law. Okay. We've got some more question and answer, I guess, but I'll still declare the students the winners. The original purpose of the attorney-client privilege is, A, to help guilty people run free. That's what people tell me while I'm on the way to the post office. It's just a way to get guilty people free. It hurt my feelings a little bit. My nephew even said something like that, and that annoyed me. But what can I do, you know? The real answer is B. Originally, this was the purpose for it, to extend it to lawyers. There had been a clergy penitent confidentiality for 1,500 years, but they came up with the lawyer-client one because as people consult a lawyer with confidence, they learn to comply with the laws. So if you cannot create that kind of a confidence between lawyer and client, people never share things with the lawyer. The other thing is that the wrong side could win. I can think of several examples where the fact that the client laid it all out to me enabled me to get justice for that client. If the client had worried that I would tell something that should have been kept confident, we would have lost the case, and we shouldn't have lost the case. I mean, we got a plea agreement one time. The client displayed a firearm but never used it, but displayed one, which is extremely punished extremely harshly in my state. If you get in a quarrel and you have a firearm displayed, not pointed at anyone, but just displayed, you know, it can be a 3-year prison sentence. Well, because I knew that in advance, I was able to prepare arguments and basically work with the prosecutor to get justice, because my client had not intentionally done anything wrong, really, just got carried away a little bit, but the other side had very, very bad intentions. And the other side was a well-known criminal. My client was basically a good guy, and but went a little bit beyond the bounds of defense of others, but we got the person into a situation where it did not become a felony record, and justice was done, and it would not have been done had the client not been able to tell me the whole story. Had I learned part of the story and then had to been surprised in court by the other part of the story, it would have been terrible. We want to find actual enforceable rules, which in the case of a legal ethics class, they're state rules. I got caps lock. Rules of professional responsibility. Lexis is best. Why? It's because we can see the case decisions that apply those rules. Some conversations like attorney and client are excluded from evidence in court. There's others, of course. An example would be somebody, let's say a man gets in a fight, and before he got in the fight, he had told his wife, I just can't stand that guy. If I see him again, I'm going to punch him in the nose. Well, the wife cannot testify about that unless the husband says go ahead. What if the man is innocent? He's the one that got punched first, and he was just trying to protect himself. The wife's testimony would create a major problem that should not be there, put it that way. Plus, it affects the marriage relationship. So there's reasons why things are confidential. Attorney-client confidentiality is kind of our focus, but you're going to find out there are other confidentiality rules too. Cases about breach of confidentiality, allowed or not allowed. Some conversations excluded from court is actually called privilege, and privilege is dealt with not in rules of professional responsibility, but privilege is in rules of evidence. Not professional responsibility. Several goals are met by drilling down using the tables of contents thoroughness, related laws and rules. It's slow at first, but it will speed, and you learn the structure, and which is the headings. So go to statutes and legislation. And how did I find it in Florida? I went to Florida, I went to this, and then I saw this, and then I just drilled down. And then I got to rules of professional conduct, which is actually the rules that they have to follow. Rules of discipline is the rules in investigation and in disciplining the lawyer. Those are not the substantive rules of how to behave in as an attorney. Those are the rules of how they have to proceed against a lawyer. Each state has two sets of rules. The basic rules of conduct are the ones we're concerned about now. And within Florida, it's rules of professional conduct, and then client-lawyer relationship has the confidentiality. You're going to find that most states, virtually all states, it's very similar to the ABA rules, but it may be interpreted differently in one state than another. Even if they use the same rule language, one state may have different rules or different interpretation. Then as you scroll down, you can see how it's applied. So you see confidentiality as applied in Florida, for instance. And then, of course, you can set up a something like this, Minnesota, do a research source, and this would be the site, of course. That way it's going to be hard not racking up lots of points for good reason. Again, these are lawyer approved. I talked to lawyers about doing this. Would you rather have this kind of a report or a long explanation where it's difficult to tell where the employee got the information? They said, I'd rather be able to go right to the information that the employee used and then be able to clearly know which part is the comments and the questions that the employee has. So they would like to be able to quickly go to what you found. Scroll down in Lexis, pick a state, try statutes first, then scroll down. You can try cases, and then, of course, rules. This week, it's mostly about the rules. And again, scroll down to get to cases, and here is Minnesota. ABA opinions, they're there, but they're advisory. But they can be helpful. And then here's a list of the assignments. I do want to kind of move along a little bit fast because I want to be able to show you different states. And this is additional things about UPL, Module 2, the slide assignment, new trainings and procedures, and basically you are trying to go over confidentiality. And of course, I'm urging you that primary sources is state rules. Okay, and I'm going to show you. I will show you Minnesota, but I'll show you other states too if you want. And then use the Module 2 rubric. You want to do the content. The way I interpret this is it has to have, to get really good, primary means primary. The ABA is not primary. It has to be state. Not ABA to get this. See, you get, what's the best you can do with just using ABA or other secondary is medium. And this does not earn nearly as many points. You want to get over to this as much as possible to the mastery end. For good reason, because your lawyer, if the lawyer says, would you look that up for me, and you find ABA, they're going to say, that's not real helpful. I want to cite for Minnesota if it's a Minnesota lawyer, Florida if it's a Florida lawyer, Texas if it's a Texas lawyer, because that other lawyer is really going to chew on this. Their other lawyer is going to get really mad if I make this report. And if we're not right about our state, we should just give up on it, even though we know that they're being unethical from our point of view. But the judges don't care about our point of view. And I don't mean to be harsh. Even a judge that, you know, let a judge and sometimes his kid played basketball with my kid. But in court, the judge gave no interest in my point of view, even though the judge respected that I did a good job as an attorney, et cetera, et cetera. No respect for my point of view. Lots of respect for state law. But do you see how that, once he puts on that black robe, it's all about state law. It's not about somebody's point of view. And I don't know how to put this more strongly. They don't give a rip about what you or the lawyer think, other than if you can explain state law in a way that makes sense and apply it to the case. Just simply how you feel about secondary sources or whatever, unless there's no law on the matter at all that's available. Judges, you got to think about it, and I realize judges are human and so on, but they're not supposed to care about your point of view about what the law should be. They're supposed to care about what the law is. And it's a 99% truth I'm giving you. Yeah, the 99% of the time, my point of view, your point of view, some other lawyer's point of view, the lawyer drums his or her fingers and says, are you making a point of law, or are you just are you just wasting my time? Okay? Yeah. Yep. And I'm just reviewing UPL. Here's an example of unauthorized practice of law statute, and this is Minnesota. I do have a Minnesota student that wanted this, I believe. And what I did was I looked up practice of law. And this is kind of review. I'm going to bring up Lexis now, because I think that was what would help you the most. I want to look up confidentiality for you and show you where it is in your state. okay? Because that helps you the most. If you cannot find your Lexis login, you need to contact me ASAP because I need to go to Dennis Johnson. Dennis Johnson needs to have it sent to your S-mail. Via Dennis Johnson. I don't do it. Dennis Johnson, our law librarian, does, okay? And you may get it direct from Lexis or from Dennis, okay? I know some lost it, but some have it. And it was almost every student has it already in their email, but you may have missed it. After starting paralegal studies, okay? And I also put it into the chat. But let's take a look at confidentiality. Please give me some states. States to look up. Yeah, I'll get it to you. In fact, I'll write it down right now. I'll put it on tomorrow's calendar to get it to you. Texas, okay. Okay. We'll do Minnesota, then Texas. Okay, I have to share content. Okay. We are going to Minnesota. And I just clicked on the state. And now I'm going to go to statutes and legislation, but I'm not going to go to statutes. I'm going to go to this, Minnesota State and Federal Court Rules. Can you guys see what I'm sharing? Is it big enough? Let me, okay, let me make it a tad bigger. Do we want civil procedure? No. Civil litigation, criminal? Nope, none of these things. Evidence we are going to be using when you get to privileges, when you talk about privileges. But right now, we're going to keep scrolling down. And it doesn't hurt to know more than what you need to know. As you scroll down, you do pick up things. But rules of professional conduct is what we want. We don't want this one, but you will use this in the last unit as far as enforcement is under that. But the substantive rules are here for Minnesota, rules of professional conduct. So I open up the plus sign. And then I go to client-lawyer relationship, which is pretty similar in all states. And then I go to confidentiality. Later on, we'll work on these conflict of interest ones and former clients. But right now, you go to this rule. Not the same numbering in all states, okay? So it gives the general rule and the exceptions. And the exceptions, you think if there's that many exceptions, that's pretty leaky. But these are extreme situations. Typically, other than informed consent. Good example is Bill, my client Bill, and after he died, his estate gave me authority to talk about how we beat the city in a civil case. they want me to share about that. So they gave me informed consent and gave it to me in writing, okay? And the rest are pretty narrow, unusual situations, okay? Now I'm going to go to another state, okay? We'll back up to Lexis. Then I'm going to go to Texas. And I usually don't go direct to cases. You can go to cases on professional responsibility and then use links that it shows you and then go backwards, then go to the rules that the cases are based on. You could do that. But you learn the rules better by going right to rules, I think, because as you skim, you will get to them. So Texas rules, trying to remember where they are. They have lots of special local rules. I think it's this one, Texas Rules of Professional Conduct, Texas Disciplinary Rules. Yes. Okay. And it's a similar rule, but a different numbering. Slightly different numbering, okay? And so slightly different, but very similar. And notice that the language is not exactly the same as Minnesota. So there may be some fine points in there. So that'd be a good reason why you'd want to give them this rather than to say, well, it's probably similar to ABA. You don't really want to tell your boss that. You want to say Rule 1.05. Let's look at Rule 1.05 of the Texas rules because we're in Texas. This is a Texas case. We're under these rules, not somebody else's. Who's got another state for me? Pretty sure we always have Florida students. I can definitely show Florida. State, local, federal court rules. And of course, we are looking really at state. And this one, I believe it's rules regulating the Florida bar. It's under there. It's one of those. And then I believe that it's not chapter 3, it's chapter 4, okay, by memory. It doesn't hurt to poke around a little bit and you say, well, no, this does not look correct. It must be chapter 4. So you find out stuff you didn't know you wanted. And then, of course, here it's 4-1.6. So it will start making a lot of sense to folks once you poke around a little bit in your home state. Who has another state for me? The only people that should not have the Lexis password and login in their S-mail email, the only ones who typically don't would be somebody who started out in paralegal studies and then rejoined 6 months or a year later. That's otherwise it's kind of an not typical. Several students every term find out that they already had it, but they just missed it. It's in a stack of emails that they didn't look at or whatever. But we will take a look at. I will let Dennis know. Both people who said they needed Lexis, we will send it to you here. Okay, let's go back and try Michigan. Let's try Michigan. I don't know the Michigan one. So I'm going to follow my own rules, not based on, I'm just going to go down from statutes and legislation to local, state, and federal court rules, and then drill down like I've been doing. Okay. I believe it would be this one, Michigan Rules of Professional Conduct. Yep. Notice that they're not structured exactly the same in each state, but they're very similar in the intent. And then as you know, in most of them, most states will have some references. Here's Michigan Digest that will help you. I don't see cases. Oh, now here are cases. Okay. And this is a secondary source, Digest, but it gets you to cases. Other states that I missed. Okay, let's go to Oklahoma. There we go, Oklahoma. Local, state, and federal court rules under statutes and legislation. This must be under statutes then, because it's not here. Here, try again. Okay, I'm late for a faculty meeting, but I will have to, let's see here. It would be under statutes then. And I got to the wrong rule, but I can go up and get to it through table of contents. Okie dokie. Thanks for working with me.